I'm Bill Auten of Auten Claims Management.
I'm Chantal Roberts of CMR Consulting, and welcome to the Art of Adjusting podcast.
Today, we're going to talk about life as an insurance adjuster from the perspective of property, auto, liability, or workers' compensation adjusters. Our goal is to bring interesting topics in the world of claims adjusting to people who are working as an adjuster now and to people who are considering a career as a claims adjuster.
Hi, Bill.
Hey, Chantal, how are you?
I'm doing well, thanks. How are you?
Good. It's almost summer. It's not quite, but
I know. I
the
find it really
weather,
hard to believe how quickly everything has gone by.
it does fly, especially when you're getting old. I just remarked to I'm working from home today. You can see my background.
Yeah,
This is, I'm approaching, this will be the longest place I've ever lived in one spot my whole
really?
life. Yeah. I
Wow.
think we're coming up on 11 years. So
Wow, that is
yeah,
crazy.
I've been a mobile kind of a guy,
Yeah.
always been moving since a kid. So, but it just dawned on me, wow, it's been 11 years already in this place.
Wow, that's great though. Well, you've got your roots because you've got your company there and everything. So
Yeah.
that's good.
Yeah.
And everybody be sure to send Bill some work because he is totally not busy at
Yeah,
all
we're
in the
just
New
sitting
York
around
in the
here
upper New York State area. He goes
twiddling
down
our
to Albany and
thumbs.
everything.
Yeah. Thanks, Chantel.
Yeah, you're welcome. Hey, what are friends for?
That's
And
right.
by the way, while y'all are sending Bill some work, be sure to like, subscribe, comment, share, all of those kind of fun things because it helps the algorithm. And then other people are randomly contacting me saying that they can make my podcast better.
Yeah, and if you're a claims manager, claims director, and some of your staff really screwed something up, call
Mm.
Chantel.
Hmm.
She can
Yes,
she'll tell you what they did wrong and tell you what to
absolutely.
do next.
Because I'm always happy to tell you where to go and what you can do with yourself once you're there. So we are talking summer liability since we're in May now. Oh my gosh. And so we're going to be talking about what's covered, what's not, and why it matters. And our summer claims, they can really look simple until we get to the policy. A lot of times, uh, the thing that I always have to look up is the lawnmower issues and policy language changes. We're going to be talking about the ISO standard policy. So your what is it? Your mileage may vary depending on what policy you have. We're going to be talking about pools and backyard injuries, which will be your liabilities as well. Rocks thrown and all of that fun stuff. So Bill, do you want to go ahead and talk about how we should, as adjusters, analyze these
Sure.
losses?
Yep. Yeah. So one of the first things we have to do is identify who the policyholder is and who is not. So if you have non-relatives living in the house and they're residents there, let's say you've got a live-in boyfriend, live-in girlfriend, they're not technically a policyholder if they're not listed on the policy. Now, if you've got resident relatives living with you, they're all insureds.
Yes,
So, but you have to be able to prove that that's their main residence. So,
yes,
if you've got an older kid that's living with you and they're home from college, but they maintain a permanent address in some other city and state, if that's their permanent address, they're not technically resident relatives. So if they make a mistake to cause injuries or damages to somebody else, you might have a coverage issue there. So those are all things to think about.
right. Like my brother-in-law, he lives here with us. His driver's license has our address. He isn't insured,
Mhm.
which
Yep.
makes me think maybe I should raise my limits a little bit.
The old
But
umbrella policy.
yeah, but our child, Aaron and Aaron's son, my stepson, who was going to and from school, still had his driver's license at our address in Arkansas when we were there. But then, now he's of course living away. But when he up to 26, I believe, is what you can do in most policies. Sometimes it's 24.
Yeah.
So what else?
Well, then we have to, if there's a liability claim, we need to figure out whether there's bodily injury or property damage. Now,
Mhm.
bodily injury sounds pretty simple. Did they cut their arm? Did they break their leg? Did they break their nose? Did they bleed anywhere? That's a pretty good indicator that there's a bodily injury. But
Mm-hmm.
if they just got sad, that's probably
Mm,
not a bodily injury. So
in
it's
most cases.
in most cases, yeah.
Yeah. No, because I'm gonna tell you, I think Massachusetts is the only state out there that recognizes mental distress if you do not have a bodily injury. So, don't quote me on that, of course, because I make stuff up as I go along, but
Well,
uh,
PTSD is often raised here as
mhm,
part of a claim,
mm,
and what value that actually has is debatable. But property damage is another important consideration. Is there actually property damage? So, and the test is to say, okay, this thing that was quote damaged, is it worth less now than it was before because of what happened? And that's really the test of whether there's damage.
right.
There's some things that can't be considered property damage, um, like loss of money.
Ah,
So, on a commercial policy in
mm-hmm,
particular, it's tangible physical property
right.
uh, is what is considered property damage. So, if you have, let's say, if you make an electronic transaction and it doesn't go through properly and the other side doesn't get paid,
Mm,
that's not going to be covered as property damage because it's not
right.
tangible property.
I
So
would say too, let's think about or look at as adjusters diminished value specifically for auto is what I'm thinking of. But I have had diminished value come up for, I don't know, couches or antiques or something to that effect when it's a liability claim. And uh, hold on, I feel like I'm going to sneeze.
go
Um,
for it. Let it rip.
yeah. So we don't, unless it's per state or something like that, but to my knowledge, we do not owe a third party claimant diminished value unless it's by state, like it changes
That's
by state.
interesting.
Uh,
So one could argue that is all you owe
mm.
is the diminishment of value. So here's how it works on property claims dealing with real estate losses. So let's say you've got a house that's damaged by your insured's negligence. So you have a contractor and they do something and it
Like cut
causes
a sprinkler line or something.
yeah.
Not that I would know anything about that. See my Facebook post.
Well, I'm talking more about total losses. So
Yes.
if you've got a situation where a house completely burns either to the ground or to the extent that it's very badly damaged, um, on the first party side, what we do as adjusters is we go in and we write a replacement cost estimate. Then if it's a total loss, in New York, I know other states do this as well. We look at the broad evidence rule and we look at all the evidence that we can find that tells us information about the value of that property. And what you wind up doing is kind of averaging all those together to come up with a reasonable value. And that's all based on statutes that are written within insurance law, insurance related first party claims. And as an adjuster, that's probably what most of your background has been. But in third party claims, it's a little different here in New York. It's a diminishment of value uh, situation in a third party claim.
Okay.
So
So you can have it.
you can have it, and that's
Hmm.
actually the way you value it.
Right.
So if the house is worth $250,000 before the fire, after the fire, if you sold that damaged property on the market, you might get 85,000. Well, let's do an easy number.
Mm.
You do $50,000. So the loss is actually $200,000, not the $480,000 public adjuster's estimate,
Oh.
not the broad evidence calculations or any of that. It's the amount that the value was diminished by the event. Um, and that's a little bit of it's a switch in thinking, but it makes more sense
Mm.
if you think about it in terms of a bucket of water.
Hmm.
The value is demonstrated by how much water's in that bucket. If the loss occurs and now the bucket is half full, you want to get them back to where they were before the fire. So you have to put uh,
The other,
water back in. So
right.
that's the way I look at that, a diminishment of value. And when it comes to a vehicle, I know, we have repairs and things like that, the actual cost. But diminishment of value or diminished value claims in vehicles is different because it talks about the lowering of value after the repairs,
Right.
not because of the repairs.
Yeah. So we also need to find out if it happened from a quote occurrence, end quote, which is the liability aspect of it. And, an occurrence again can mean a whole bunch of different things depending on your policies, but I think I pulled it just from the homeowner's policy. It means an accident, including a continuous or repeated exposure to substantially the same general harmful conditions, which results during a policy period in a bodily injury, which is in quotes, which means it's defined, and property damage, which again is in quotes, and
Or
or property damage, which is in quotes, and again defined. And we've just been talking about that. Got to look for exclusions.
Yep. Yep.
Eh,
If it does pass the test of an occurrence,
mhm.
and it sounds so silly, what's an occurrence? I mean, in everyday language, an occurrence just means something that happened, but in the policy, it just means something a little more specific, and it's got to fall into that category, or otherwise, it's not a covered claim.
Right, absolutely. And I have read an article that quotes judges saying, man, for want of a definition, we all think we know what occurrence means, but that's one of those words that's really hard to define, and the policy tries to, but there you go.
Right.
So, you're looking at exclusions after you make sure that you have an occurrence. And the reason why you're looking for exclusions is not to look to see what you can deny, but it is, again, most part, eh, the policies are special policies, which means everything is covered except what's excluded. And lay people believe that we as adjusters are always looking for exclusions. It's not that we're looking for ways to deny the claim, it's that we need to find coverage. And the only way to find coverage is basically to prove a negative.
Right. And and I would argue that it's not the adjusters that are looking for ways to not pay a claim. That was done long before the claim ever happened. That was done when the policy was written.
Mm,
The drafters of that policy form knew what they were accepting as risks
mhm.
and what they won't accept as risk, and that's why those things are in there. Our job is to just see what those lunatics wrote.
Exactly. Exactly. And then, of course, there's always the exception to the exclusion, which is the fun thing where we say this is excluded, but we may give coverage back here only under this circumstance if like this particular cause of loss happened, and only for maybe a certain sum, like a sublimit for $500, $1,500, 2,000, whatever.
Unless they put this endorsement on there that changes everything anyway.
Right.
And that's why I say lunatics when I talk about the folks
Yes.
that draft these things.
Which is also the reason why you have to read the entire policy every single time, every
Yes,
page. Yes.
yes. And will it turn you into a lunatic to read them? Yes, it will.
Yes, it will. So let's jump into lawnmowers, one of my favorite topics. And this is one that a lot of people think that they know. Everybody thinks, oh yeah, lawnmowers covered. Great, except for maybe when we're mowing our neighbor's yard or whatever, depending on what the policy says. So, for example, I have a neighbor next door who mows our elderly neighbor's yard. Would there be coverage for my next door neighbor who mows his yard, mows the neighbor one door down yard? Depends.
Yeah, so the language is that it must be used primarily to service the resident's premises.
Mhm.
So, what is primarily? That means probably more often than not. So, if you're engaging in one of those days where it's not being primarily used to service the property, instead it's being used to drive to the grocery store to pick up groceries, and
Yeah,
See
not
that a
going to be
lot around here.
really.
Um, oh yeah,
Oh,
we live out in the country here, so
oh,
you never
okay.
know what you're going to see.
See, well, in Arkansas, I guess we get four wheelers. So we'll see the four wheelers get, going up and down to the grocery store, to liquor store and all that kind of stuff. But again, you know me, I like definitions. So when you're looking at a normal HO3 and the edition date is 511, which is what most of us are using now, if not a manuscript, but even the manuscripts may be based off of the standardized policy. A homeowner policy will exclude motor vehicle liability. A motor vehicle is a self-propelled land or amphibious vehicle, per the definition, which a lawnmower, a riding lawnmower would fit into. Now, we
Correct.
talked about that exception to the exclusion, and one of the exceptions to the exclusion in the HO3 511 policy is the exception for vehicles used to service a residence premises. And of course, a residence premises is where someone lives. Um,
And you're saying letter A, not
yes, like
a residence premises.
it's instead of the residence premises. So
Right.
like service a residence premises. So like my neighbor servicing my other neighbor's yard would be okay because it is a residence. Now, if my neighbor went over to a church to mow their yard, not covered because that's not a residence premises unless the priest or the preacher or whomever lived there. Bill Wilson, who we've talked much about, and if you don't follow him, please do, has written many a blog article about this, and so I've pulled a lot of his things on here. Also, for liability, uh, motor vehicles are excluded, and there's still no coverage. There's if an exclusion A1, which was, there's no coverage E and F, which is liability and med pay for a motor vehicle. If A1 doesn't apply, there's still no coverage for the motor vehicle liability unless the motor vehicle is used solely to service a premises.
A premises, yes.
Now, that one says solely. So again, if you do a side gig or your kid does a side gig, then it may not be covered.
Right.
So something to think about when you as an adjuster, because as an adjuster, you're sitting there going, great, there's coverage. This is when you need to go ahead and get that recorded statement done and
The details
drill,
matter.
yes, and drill down on getting all of the details from the insured. When do you mow someone else's yard? When does your kid mow someone else's yard? When do you mow the church's yard or whatever?
Yeah, we see a lot of claims involving four wheelers and UTVs,
Mhm.
and those get tricky because a UTV, they're sport models that are just used to go off-roading and have fun in, and then there's more utility ones that have speed governors on them. They're not designed to go fast. They have beds designed to haul materials and stuff. They're clearly more utility than recreation,
Right.
but its usage is really what governs it. If it is one of those utility type vehicles with a dump bed, but it's only being used to you know sightsee on a big property somewhere, that's doesn't meet the definition. It has to be used to maintain the property, depending on the policy language. And we use
Mhm.
a lot of we come across a lot of different forms that are worded just differently enough to change the way some coverages are going to fall down.
Right, because we're talking too, we can talk about how we have damage to property of others, like we throw a rock or something like that, or we run over a boy or whatever with our lawnmower. And so it actually says our HO 3511 says we're not going to pay for property damage for damage to property of others. Um, where the ownership, maintenance, occupancy, blah, blah, watercraft of motor vehicles. It doesn't apply to motor vehicles. That is a designed for recreational use off public roads. And I would say riding a lawnmower is not recreational use. So
Right, unless you're using it for recreational use.
why would you
As an
use a lawnmower for recreational use? What
Oh,
recreational use would you have for a lawnmower? Please educate us, Bill. I'm going to take a excerpt of this.
I will have to send you a series of photos I took last year at the county fair for the lawnmower tractor pulls.
Oh, okay. 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 I stand corrected. I stand corrected. Um,
You should see these things. They're all tricked out. They're all painted up, and there's a bunch of young people, a bunch of middle-aged people. There's a bunch of old people do it. It's actually amazing. I'll have to share some of the photos with you.
oh yeah. Yeah. We need to see these on LinkedIn as well. Okay. So the issue too is that of course ISO has updated their policy forms because they understood that there was this whole kerfuffle about is it covered, is it not covered, blah blah blah, you know. And so the HO30322, which is the most recent, and honest to goodness, I have not seen this in my expert work yet. If anything, I see the 0511, which is again one of the reasons why edition dates are important. So always make sure you're reading the correct edition date of the policy, but also I see a lot of, like you, manuscript policies. In this particular instance, they have changed, they've amended the lawnmower exclusion. So there's coverage for a riding lawnmower that at the time of occurrence is being used to mow a lawn. So then our joyriding ones would not be effective.
There we go.
Yes. So if you're on, oh my goodness, if you're on YouTube, you can see these things. This is great. Just another, you know what? I have seen these. We have a sunflower festival that shows these.
These guys really get into it too. It was a riot. It was just so much fun watching these guys, and they go so slow.
Oh yeah, yeah, yeah. There's no like buildup of anticipation. You're just like, yeah.
Anyway, I'll that's enough for now. But yeah, so there's a lot of fun you can have with lawnmowers, apparently.
Yes, I guess there are. Yes. So again, here's my thought though too for our adjusters is everybody is talking about a riding lawnmower. And of course, as an expert witness, this is one of the things that I key up on is of course wording matters. And that's one of the things that you and I talk about a lot, Bill.
Hmm.
And so my thought is if the definition speaks about a riding lawnmower, what about a push mower?
Well,
My yard could have a riding lawnmower, but probably a push mower would be fine.
yeah. So it's a it's not a vehicle.
Mm-hmm.
It's a device that you push.
Mm.
You don't
So you would say it would fall under a completely different, it would be more of a thing that would be servicing the house, like
right.
regular contents. Okay.
It's kind of like a blender
Mm,
or a if it would fall in the same category as a tool
mm.
or you know so I don't see that as I mean what about a weed whacker?
Well, yeah, I don't see a weed whacker as being something that we would ride, but we keep talking about lawnmowers, lawnmowers,
Right,
lawnmowers.
right, right.
And so there is a difference. There's the riding kind and there is the push kind. And
I
so
think that one exclusion in here actually said riding lawnmower, I
yes,
think.
it did.
Okay.
It specifically would say riding lawnmower. And um I because I had put in our notes, but I can't find it right now. But I know
Yeah,
that
I
there,
have it here. HO 2021 OFR 21 amends the lawnmower exclusion so that there is coverage for a riding lawnmower that at the time of occurrence is being used to mow a lawn. That
right.
means there's no coverage if you're going to the liquor store. Uh,
So all you
Chantal.
Arkansans out there, uh,
That's for you, Chantal.
And all my cousins, y'all got to know it's not going to be covered. And lawnmowers do throw up rocks.
They do.
They'll chew up, I guess, a toy or something like that. Injuries to passerbys. I have worked a couple of projectiles into the cars where the a rock has damaged a car window or whatever. So you got to know.
Lawnmowers in general can be very dangerous.
Mm,
And the one thing I would say to anybody listening is do not walk backwards with a push lawnmower. Um, I've seen some terrible, terrible injuries to feet in particular.
mm,
So um, just go forward
right.
and don't go
So
backwards.
right. So still an occurrence, yes. You need to look at negligence versus our accident. Our negligence rules like an ABCD rule that we've talked about. Know if we're talking about bodily injury versus property damage. If you have a business use on the side or your kid does and is using your lawnmower, there may be a problem.
Yeah, for sure.
So just like I say with our trespassing slash business invitee slash, which we're going to get into next with pools versus invitee licensee, you can be all three at one time, depending on where you go and what you do. So the same mower could be covered at 10 a.m. and excluded at 2 p.m. And that's
Depending on what you're
why,
doing with it, that
yeah,
is correct.
and that's why it is so important for you adjusters to take a good recorded statement. Pools. Let's talk about
Pools.
pools because my
Yeah.
neighbor has a pool and I've been learning all about Overland Park's rules about pools. Fascinating.
Yeah.
We're very bougie. I don't know
Are
if
you?
you do that or not, but we are very, very bougie over here.
So the rules that I'm familiar with is that you have to have the access has to be controlled by a self-closing, self-latching gate.
Mhm,
And if it's an in-ground pool, there has to be a fence around it,
mhm.
so to prevent anybody from coming in. But even if it's above ground, you still have to have, whatever access you have still has to have that gate.
Yeah,
Um,
so here in Overland Park, they want the pools to have covers on them. The gate has to open outward. So like if we were in the pool area, it opens outward to the yard and the gate self-latching and has to be able to be locked, which is of course very interesting because my neighbor has a lock like they're supposed to, but they have the key in it. And I'm thinking, well, that's not very good for kids. And then the gate has to be 5 feet high, like the latch has to be at least 5 feet high. And I'm also thinking, kids are pretty inventive. They can get in with even a 5 foot high gate. But this is what really made me think about this. We have a green space behind our houses. And some of the kids were playing baseball and the balls come over to our fences all the time. And so they'll, hop in or open the gate and come in, get their ball and head right on back. It happens. Well, the neighbor like, has the gate locked. That one didn't have a key on it because it backs up to the green space. The gates, that fence is only 4 feet tall.
oh, okay.
So the kid who has to be what, 11, 12, 13, something like that, hopped over the fence
Yeah,
to get the ball.
right.
And so are our insureds then protecting the children? Because you got to think about it. If I were to hop over the fence, I'm trespassing. I'm an adult. I don't have permission. And then if I get injured by drowning in the pool or something to that effect, then um, the onus would be on me, not them.
Mm.
However, 12, 13-year-old should know better, but they're usually treated like business invitees, where we have to do a little bit extra.
Attractive nuisance.
Yes, attractive nuisance.
Yeah, well, And children are unable to make their own decisions in life too. That under the law, they
Yes.
when you are a certain age, you're kind of absolved of your sins in terms of comparative negligence.
Mhm.
So there's that too. But when it comes to pools, you can have the best fence up to code. You can have the best gate up to code. You can have the best insurance coverage in the world. Nothing absolves you from your duty to recognize the risk involved in owning that pool. And I, you should probably have these days cameras out there, motion
Yeah.
cameras, so that if nobody's out there, nobody's supposed to be out there, you find out, you get a notification that something's going on.
That's a
Because
yeah.
nobody really wants to find something bad has happened in their pool.
God, no. But that's a really great idea for adjusters to ask about. Do you have ring cameras in your backyard or something to that effect? So, great question to ask because we do have a lack of supervision issues. Back in the 80s, they really believed in the Darwin theory of raising children. So
Hmm.
I could go next door to my neighbor's pool when they were at work, my parents were at work, I was home alone. I could go swimming in the pool.
Hmm.
There was no supervision. You know, they told us to go play out of the streets back in the 80s. Just
Yep.
don't get hit by cars,
Right. Watch out for the cars, but
the
go ahead.
cars will hurt you. There was no yielding for
Mm.
children playing in the street kind of deal. So yeah, you've got the lack of supervision. You have the attractive nuisance, like I was talking about. Those things are really interesting to kids because kids want to play in the pools, and that's why Overland Park has said, okay, you've got to have gates this high. You have to have locks on them. Yada yada yada. So our neighbor, actually, what she has is she has a gate that's 5 foot high, but the rest of her fence is 4 foot. But I mean, but look, she's complying with code,
Yeah. Yep.
even though maybe the spirit of the law is to have a 5 foot fence, regardless. Like I said, I literally saw a kid jump over the fence to get the ball. Um,
Laws and regulations can't protect you from everything, and
it's
insurance
true.
policies can't protect you from everything either. You have to recognize the risks that you are undertaking when you own a pool or a trampoline or something like that, and you have to take steps to protect yourself and protect
Yes.
others.
So let's talk too about wet surfaces, slip and falls, and that sort of thing, because outside in a homeowner's space, usually there's concrete and you may not slip so much because there's traction. But what if you are a gym or something like that and you have a pool? Well, you usually would have some kind of tile or whatever. So you need to be sure that your insured is walking that area a lot or their employees are walking that area a lot. You've got those wet floor signs, maybe mopping up a big puddle, even though the floor would still be wet. But again, like we've said before, there's also a duty on the walker to know that a tile would be slippery when it's wet.
Right. Yeah. We had a case where someone had outdoor tile
Mm,
in a parking lot,
mm.
and it was a sloped parking lot. And it was hard to walk on when it was dry. I can't imagine what it'd be like when it was wet.
Mm.
Um, but yeah. Anyway,
Yeah. So,
tile around a pool makes sense. Tile in a parking lot, probably not so
not
much.
so much. Also, ask your insureds about umbrella policies because when you do have a child who is injured, or God forbid, deceased, this can be very expensive and it can breach your policy limits very, very quickly. So, what you're going to want to do is speak to your insured, actually speak to them, find out if they have umbrella insurance, get that policy number, that policy, the insurer, if they have an adjuster, their name and number, call the adjuster and tell the insured in writing and verbally, you need to file a claim, at least for notice. And then what I would recommend that you do is also call the carrier and place them on notice. Because even though that's not maybe technically your job, unless we're talking commercial, then maybe it is. Um, Sometimes the insurer doesn't do it, and then they can be denied again for late notice for the umbrella. And you definitely don't want, like, I don't know, a $3 million, you know, demand coming in or verdict or something like that, and you only have 500,000 in
Yeah, it's
savings.
good to keep the umbrella adjuster kind of
And
apprised of the status of things as well, so that they know whether or not this is something that's actually going to, you know, at the outset, you might think, oh, God, this could be a limits case. But as you go through it, you might learn some things that maybe suggest maybe it isn't, or maybe it is and it's really bad. So always good to keep dialogue with those folks too. And I
absolutely.
think most times the umbrella carriers that I've dealt with, they're appreciative of that. Um, but they're not doing the same investigation that we are,
Right.
you know, on the underlying limits. You know, we're doing most of the work. They'll analyze it afterwards, but they do want to know as we go
Mhm.
because they've got reserves to set as well, and they've got supervisors to answer to and all that.
Absolutely. Yeah. So what about, I think about med pay too in these kinds of situations. What do you think about that? Because
MedPay,
usually, yeah, yeah, or quick
uh,
payments or litigation expenses, because all of these are big deals, especially if you have coverage, if you don't have, or if you have liability, I should say, negligence, or if you don't have negligence.
so MedPay, you know, traditionally is kind of designed to maintain control of those smaller claims so that they don't balloon into something later on. And from that standpoint, it's always been kind of a tool. Um, it's usually not a large limit. We see some policies with $1,000. What's that going to do? You know, maybe take care of prescriptions. Um,
Nowadays,
Other policies have higher med pay, you know, 10 or $15,000. Um, Nonetheless, as I said, it's a tool to try and, you know, keep control of the claim. It complicates things with Medicare
yeah,
because
yeah.
we can't even make the med pay until we get the Medicare lien. So
Is that true? I did not know that.
yeah,
Mm,
so um, you know, we just don't know what what that lien is going to be, and if we spend the entire med pay limit paying the claimant, we have to pay it again for the lien. So you know, we don't want to do that.
yeah.
Um, so it is kind of a chicken and egg thing with the CMS liens.
Right.
Um,
And
Makes it
just FYI,
complicated.
adjusters, Bill, this would be a great podcast to talk about CMS and the steps we have to go through. But also, adjusters, you need to turn in your third party claimant to CMS. And by turn in, I mean report them, see if they
Report it.
are, yeah, Medicare or Medicaid eligible. And because they have an automatic super lien. And last I heard, it was $1,000 a day fine if you didn't pay them and they had made payments and all of that kind of stuff. And nobody, even insurance companies, can't pay $1,000 a day fine for every day that you have not paid the lien back. And so there's a lot of steps you have to go through. It's one, and I have had attorneys go, look, the kid is 3 years old. I'm like, don't care. Do
Hmm.
not care.
Yeah.
Gotta run them through it, you know.
Yep.
So
Pretty
unless you want to
much
get me
all
something
my
in.
clients are like that. We got to get that reported, and it's not just Medicare, it's Medicaid also.
Mhm.
Um,
Right, right.
so
It's both. So yeah, we should do some. I'll write that down. We should absolutely give that a talk over. So we're in the backyard talking about pools.
Yeah.
and lawnmowers and everything. And you mentioned trampolines. And so those things, man, do you remember those things in the 80s? They were so much fun. You would fall off and break an arm. Nobody
Oh
cared.
yeah.
Because again, it's the Darwin theory of of child rearing. Uh,
So I don't know that there's many homeowners listening to this, but if you're a homeowner and you have a trampoline, you should run to your policy right now and look to see if you have a trampoline exclusion, because if you do, and somebody gets hurt on that, somebody outside your family, somebody in your family is not going to be covered under your homeowners, just so you know. We've had those claims before.
why I
But but if a neighbor's kid comes over and breaks their arm,
mm,
and you've got a trampoline exclusion, there's not going to be any coverage. It doesn't mean they can't sue you. It just means that if they do, your insurance company is not obligated to defend you or pay any claims for you.
right,
So
right.
um, then you've got to ask yourself, do I want to find a way to eliminate this trampoline exclusion,
Mhm.
or do I want to find a way to eliminate this trampoline? And
Yeah, and
I would say go for the second option,
yeah,
personally.
which would be less expensive. So I know again too, again, adjusters, when we're doing these recorded statements that we're talking about, a lot of cities also have rules that you have to have that netting around so that
Right,
kids cannot fall out or
right.
off. And then I have even seen, which I was like, oh, that's a great idea, but my God, that's expensive. Trampolines that were built level with the ground because they've dug a pit in the ground. So when the kid falls off, they just fall on the ground. And I'm like,
Right.
yeah, it's a great idea, but also,
Well, falling off the trampoline is one risk. The other risk, which is almost as bad, is when you've got multiple kids in there and they're bouncing off each other, and
yes.
you wind up with concussions.
Oh, yeah. Yeah, yeah. And it's not to say that you can't twist an ankle or something like that when you're jumping up and down with even by yourself
Hmm.
but with all of the kids doing all sorts of somersaults and backflips and all of the fun things that you can do on a trampoline. So,
If you have a neighbor's kid over, it's hard for me to imagine a scenario where you would not be found liable for injuries to that kid if they got injured on the trampoline, because
because remember your duty changes when there's a child.
mhm,
Even
you're
though you've invited the child over, I mean, obviously. So I would sit out there, or I would have an adult sitting out there having some supervision. And that's when you yell while you're holding your beer or your Shiraz or whatever, no horseplay. Knock it off. If I have to get up and put my wine down,
yeah, and that certainly wouldn't help the liability picture if you were
no, absolutely not.
anyway.
Um,
Um,
Yeah, so you've got safety features, you've got supervision that you have to do. Most of these things we've talked about before, but again, I think your point mostly is be sure adjusters to look at the policy and see if there's a trampoline exclusion.
yeah, the best way to protect yourself from trampoline claims is not insurance coverage, it's avoidance.
Hmm. Yeah, yeah.
Which my kids always wanted trampolines, and I was always on the no train. Sorry,
Yes.
kids. Why don't we just go run at the track at school instead?
I always wanted a trampoline and my parents always told me no. But to be fair, my parents also said I could never go skiing too because they were always, and so I desperately want to go skiing sometime. Not water skiing, snow skiing. I do want to do
Well,
snow
skiing
skiing.
is one of those assumption of risk
Uh,
things that I just I think horseback riding should be considered that as well.
I would think
But
it would be
yeah,
for the
it is
most
for the
part.
most part. But
Yeah.
you get some catastrophic injuries.
Oh, of
Somebody's
course.
getting sued.
Oh, yeah, yeah, yeah. I mean, because you can fall off a horse and have a really good major concussion.
Yeah,
So
yeah.
fire pits and grills, of course, everybody is grilling, and we've all had the podcast before, and we're not going to get into it. Where if you have the fire too close to the house, it's sparks are going to go up, and there's always some insured that wants to deep fry a turkey in the garage And you're like, no, why did you think that was a good idea? First of all. Um, so yeah, we've got your friendly fire and your hostile fires. So can you talk about that?
Yeah. So if you've got a fire pit, if you're allowed to have one where you live, uh, and you build a fire that's a little too big and the wind blows a little too hard, and some embers go onto the neighbor's deck and start their house on fire, um, yeah, you're going to be found liable for that. And chances are what's going to happen is that insurance company is going to pay for the damage for your neighbor to your neighbor's place, and then they're going to subrogate against you. Um, you should have informed your liability carrier long before subrogation happens anyway.
Yeah, absolutely.
But again, that's another avoidance thing.
It
You're
is
better off not having a fire on a windy day. Um,
true. And again, adjusters, I'm kind of hitting this pretty hard, and I'm thinking we're going to need to have a podcast about recorded statements. But again, adjusters, when we're taking our recorded statements, this is when you need to be asking your insured, did you know what the wind was going to be? And you should look up what the wind is at the wind speeds. And we've talked about various weather websites.
yeah, for sure. The other thing that we have with fire pits in general are people falling into them or
How
stepping
big are
on
these fire
onto them.
pits?
Well, um,
Or is it because I didn't, I'm yelling at the kids to stop horse playing in the trampoline and
run,
I had to put
there,
down my Shiraz.
people run around them, kids run
Yeah,
around
yeah,
them.
yeah.
I had a claim where a woman stood up off a bench and lost her footing and fell right into the fire.
Oh,
I've had people trip over them. Like a lot of people will use like an old tire rim,
mhm,
and at night somebody's stumbling through the yard
mhm.
and they'll trip over it. It's happened during the daytime. We have, oh yeah, all kinds of fun.
All kinds of fun.
We've had people have an open fire in the yard and then they put the fire out because they're leaving for the day or whatever, but the coals are still there. You just can't see them,
Mhm,
and somebody steps in it.
mhm,
That's a bad day.
mhm.
So
Yeah. We've talked previously, you and I, about the intentional acts exclusion, and you came up with a great rewording or rethinking of this exclusion because most people go, oh, it's an intentional act. Boom, it's excluded. And it's not
I'm
so
sure it
much,
was brilliant. I just
it,
don't remember it.
I will, well, I'm gonna tell you what it is, and I'm gonna
Okay.
give you full credit.
All right.
Is there is intentional act. There is an intentional acts exclusion is the very first one, but the way that you worded it, Bill, was it's more of an intentional harm because
Oh yeah, yeah.
we as insurers pay for stupidity. So if you intentionally set something on fire, but you didn't intend for it to catch your neighbor's yard on fire, then maybe it's excluded, or it's not covered, or it is covered. I want to give an example that I just recently saw. I My husband and I are watching The Rooster, and I don't know if you're watching that show or not,
No, never
but
heard of it.
oh, it's good. It's with Steve Carell as the
Oh,
main guy. Anyway,
yeah.
Steve Carell's daughter in the show is going through a separation with her husband, and she burns her husband's book, his favorite book. It was a first edition, only translate, like pretty much the only edition in the world of this book. It's very, very rare, very special to the guy, blah, blah, blah. She puts it in the chimney, sets it on fire, and realizes when sparks start going up that the chimney cover is down and she can't get it open because it's, stuck. So now sparks are going all over the room. She's trying to put it out. The whole house catches on fire. She intentionally burns the book.
No coverage for the book.
No coverage for the book, but she unintentionally burned the house down that
Right.
there would be coverage. And okay, we're gonna like ignore the fact that the wife burned her own house down, but I mean, you get the point,
Right. Right.
of that issue. So in our fire pit issue, if like maybe, I don't know, our fire pit burned our tree and then burned our neighbor's house, maybe our tree wouldn't be covered, but the neighbor's house would.
So
So
I want royalties when ISO changes their language to intentional harm.
I think you should demand that. It was a very good rethinking of the idea. And in fact, I use it in my class when I'm talking about commercial general liability, and we're talking about Drake and Lamar's little feud over those issues with the rap songs and whatever. All of the students immediately go to, oh, that's an intentional act. There's no coverage. And I'm like, yeah, there would be. It's did he intend there to be harm in that particular instance when he's calling someone a pedophile? Hmm. Anyway,
Hmm,
so your
interesting.
negligence will drive your analysis of liability.
Your negligence, but your intent.
Yes, your
Um,
intent. Yeah, yeah.
yeah.
Um, so there you go.
There you
That's
go.
yeah. We've got dogs that are in the backyard.
Oh, dogs.
Yeah, yeah. We've
So
talked about dogs before,
we
but
have, but we need to update our talk because the law changed here in New York. There's a
oh,
new court decision
oh,
that
good.
has it hasn't negated the one bite rule
Mm,
that we had in New York. And for those who don't know, one bite rule meant that if your dog never bit anybody before, that you technically had no notice that the dog had any vicious propensity, so you were free from liability. But if the dog had bitten somebody before, you're now on notice of that dog's vicious propensity, and you become strictly liable for any dog bites that happen after that. So what that does is removes the concept of negligence from the argument. In New York, it was just a strict liability situation. If the dog bit somebody prior, you are now strictly liable. That's the test. However, this new decision, and I can't remember the name, Fellows maybe? Anyway, the new decision allows negligence to also be made. So now you can argue strict liability and vicious propensity, but you can also argue negligence. So if your dog never bit anybody before, but you accidentally left the door open and the dog
mm.
got out and bit somebody, negligence now triggers liability, and payment has to be made
This
for
is a great
damages.
topic because I have questions.
Yeah.
So we'll get into it.
Yeah.
But yes, bite history, again, you're going to know this adjusters by taking your recorded statement and asking about it, maybe doing a search in your system, seeing if there's been another dog bite or the ISO claim search feature. Breed exclusions, this is rapidly going out of style because some municipalities and states have said carriers can't exclude certain dog breeds. So be aware of that. And again, adjusters, this is where you need to like do a search and around your states and municipalities to see if there are those restrictions, like insurance companies can't exclude pit bulls or German shepherds or whatever.
The new if you're in New York, the new decision is Flanders versus Goodfellow.
There you go. There you
That's
go.
the new law in New York, and that happened. I want to say it was about this time last year,
Mm.
maybe midsummer. Um, what's the date here? I can't find the date, but it was last summer anyway. Um, I started to get I started to get letters from attorneys saying, see, because we had, I don't know how, at any given time, we probably have 20 or 30 open dog claims. And all the attorneys were sending us letters with the decision attached.
Oh,
So,
wow. Oh,
yeah,
wow. Okay. Well, let's see. We've covered a lot of things in
we have
in our talk in our
summertime.
summertime sadness of liability claims, I guess. So,
Well, it's
location.
not just winter that keeps us busy.
Oh gosh,
Everybody
no.
thinks slip and falls, and that makes up a huge chunk of what we do. But Summer keeps us really busy
And
too.
we haven't even talked about hurricane claims. Woo!
Yeah.
So location matters. You, for example, for our lawnmowers, if you're on premises, if you're off premises, you got to look at that liability definitions are the language of what we're using a certain tool for.
And we talked all about third party liability here. We
Yeah.
could do a whole other episode on first party liability with these same issues,
Mm,
these same kind of like lawnmowers, for example, or recreational vehicles. They're just, if they're not used to service the property, they're not covered if they get stolen or damaged in a fire or something like that.
very true.
Um, so there are certain types of pool damage that won't be covered. Like if the ground shifts underneath and it cracks, it's not going to be covered.
Yep.
So there's we could again do a whole episode on first party only.
Yeah. Fun. Maybe we will. Maybe we
Maybe we
won't.
will.
I don't know.
Maybe
We have so many topics. And in fact, if y'all have a topic that you want us to talk about, drop us a line on LinkedIn, either on Spotify or YouTube or something like that. And we'll go, we don't know anything about it, but we'll make
we had
something.
lots of fun here in New York. We could talk about Labor Law 240. We could talk about dog bites and the new decision. We could talk about the Avoid Act. We
Yeah,
could go on and on
we
and
can
on.
go on and on and on. Your intentions matter. Intentional acts are covered. It's intentional harm or intentional acts, I don't know, aren't covered, but it's intentional harm that is covered, I guess is what you could say. No, did I get that backwards?
Backwards.
Oh, okay. So intentional
It's
acts are covered. Yeah, because we cover for stupidity. Thank you.
right.
So intentional acts are covered. It's intentional harm that we don't cover. Thank you.
Right. I
Thank you for
intended
calling.
to start the fire in the fireplace, but I didn't intend for it to leave there and burn my house down.
Exactly. So anyway, and your status as guest, watch out for children because their status changes because their poor little brains are not developed.
And if you have a live-in boyfriend or girlfriend,
Yes.
you want to make sure they're on the policy or that they have their own separate renter's policy
Yeah.
and
Yeah.
that you have a rental agreement with them.
Yes, please. So it's not just about, bad luck or anything like that. It's about all of these little details that we've got to get nailed down. And in our recorded statements, in our discussions with the insured, talking about these things with the insured on our first conversation, maybe our second conversation as we learn a little bit more.
All right, cleaning crews here, so there's some
Oh,
background noise. I hope that's not bothering you
no,
too
well,
much.
we're going to go ahead and conclude anyway.
You
So
bet.
in 2 weeks, on May 21st, our topic is going to be Memorial Day and beyond, the holiday weekend, and liability trends and risk patterns. So we're going to talk more about that. And again, be sure to like, subscribe, share, comment, all of those sorts of fun things.
Absolutely.
So we'll
I
see
will do that.
you in 2 weeks.
Yes, ma'am.
Okay, bye.
Take care. Bye bye. Thanks for joining us on the Art of Adjusting podcast, where we talk about life as an insurance adjuster.
If you enjoyed this podcast or this episode, please give us 5 stars and a review. It does help the algorithm pick us up.
Hit that subscribe button real quick and tell all of your adjuster friends to check this out as well. For independent adjusting services, go to www.auten.claims. And for anyone interested in working as an independent liability adjuster, go to the Contact Us tab to join our roster. In the meantime, you can contact me at theartofadjusting.com for consulting and training purposes.